Imagine walking home through the streets of ancient Rome late one evening when a group of men steps out of the shadows, beats you, and takes your money. You survive, but you are injured, robbed, and outraged. Now here is the shocking part. There is no one to call, no police station to report to, no detective to investigate, no prosecutor to file charges. If you want justice, you will have to find those men yourself, drag them to court yourself, and prosecute the case yourself, or simply accept your losses and move on. So sit back, grab a cup of tea, and get ready to discover how Rome had no police force as we understand it. Learn how citizens caught criminals and brought them to court without any help from the state. Understand how the Roman legal system relied entirely on private prosecution, where victims bore the burden of seeking justice, and explore what this extraordinary system reveals about Roman society and our own assumptions about law and order. The idea that a major civilization could function without police seems almost unthinkable to modern ears. We are so accustomed to professional law enforcement that we assume it has always existed, that any organized society must have police. But the Romans, who built an empire spanning 3 continents and lasting centuries, who developed sophisticated legal codes that still influence law today, had nothing resembling a modern police force. There were no detectives investigating crimes, no patrol officers walking beats, no prosecutors bringing charges on behalf of the state. Justice, in the Roman world, was largely a private affair. This does not mean Rome was lawless. Far from it. The Romans developed one of the most sophisticated legal systems of the ancient world, with detailed codes, professional advocates, established courts, and careful procedures. Roman law became the foundation for legal systems across Europe and beyond, influencing modern concepts of contracts, property, evidence, and procedure. But the enforcement of that law worked very differently than what we take for granted today. The fundamental principle of Roman justice was private prosecution. If someone wronged you, stole from you, assaulted you, cheated you in a business deal, or even killed a member of your family, the responsibility for seeking justice fell entirely on you, the victim, or in the case of murder, your surviving relatives. You had to identify the wrongdoer, gather evidence, secure witnesses, and bring the accused before a magistrate. The state provided the courts and the legal framework, but it did not investigate crimes or prosecute offenders. That was your job. Consider what this meant in practical terms. If a thief stole your money, you could not simply file a police report and wait for officers to investigate. You had to find the thief yourself. You had to prove he was the one who robbed you. You had to physically bring him, by force if necessary, before a magistrate who could hear your case. If you succeeded in all of this, you might get justice. If you could not find the thief, or could not prove your case, or could not drag him to court, you had no recourse. The crime simply went unpunished. This system placed enormous burdens on victims, particularly those without resources. A wealthy Roman who was robbed could send his slaves to track down the thief, hire advocates to plead his case, and call upon a network of clients and associates to support his prosecution. A poor Roman who was robbed might have no realistic way to seek justice at all. The system was not designed with equality in mind. It reflected and reinforced the hierarchies of Roman society. The Latin term for bringing a legal case was actio, from which we get the English word action. When you brought an actio against someone, you were the actor, the one taking action to seek justice. The accused was the rias, the defendant, but there was no public prosecutor to stand with you, no police force to have conducted an investigation before you arrived in court. You stood largely alone, bearing the entire weight of proving your case. The magistrate who presided over most civil cases was the praetor. This was an elected official, one of the senior magistrates of the Roman state, who held office for 1 year. The praetor did not investigate crimes or pass judgment himself in most cases. Instead, his role was to grant or deny permission for cases to proceed and to appoint judges who would actually hear the evidence and render verdicts. When you brought a complaint to the praetor, you were asking for a formula, a formal statement of your claim that would frame the legal issues for the judge to decide. The praetor maintained an edict listing the types of claims he would recognize and the formulas he would grant. If your grievance fit within his edict, he might grant you a formula and appoint a judge. If it did not, or if he found your case without merit, he could simply refuse to hear it. The praetor was, in effect, a gatekeeper to the legal system. This formulary system was characteristic of Roman civil law during the Republic and early Empire. It was remarkably flexible, allowing praetors to adapt the law to new situations by recognizing new types of claims. But it also gave enormous discretion to individual magistrates. A praetor sympathetic to your case might grant a formula readily. One who was not might find reasons to deny you access to justice. Criminal cases worked somewhat differently. For serious crimes, murder, treason, electoral bribery, and other offences that threatened the community, Rome developed specialized criminal courts called questiones. These standing courts had juries drawn from the upper classes and could impose severe penalties including death, exile, and loss of citizenship. But even in these criminal courts, prosecution remained private. A citizen had to step forward, accuse the defendant, and prosecute the case. There was no public prosecutor equivalent to a modern district attorney. The men who prosecuted cases in the questiones were often motivated by personal grievances, political rivalries, or the hope of advancing their careers through successful prosecutions. Young advocates, seeking to make their names, might bring cases against prominent figures, gaining reputation and influence through dramatic courtroom battles. The line between justice and personal ambition was often blurred. Perhaps the most famous prosecutor in Roman history was Marcus Tullius Cicero, the orator and statesman whose speeches still survive and still influence rhetoric today. In 70 BCE, the young Cicero made his name by prosecuting Gaius Verrus, a corrupt governor who had plundered the province of Sicily during his administration. Cicero's speeches against Verrus, known as the Verrine Orations, painted a devastating picture of greed, cruelty, and abuse of power. The case against Verrus illustrates both the power and the limitations of Roman private prosecution. Cicero was approached by Sicilians who had been victimized by Verrus and who wanted justice. But bringing the case required enormous resources and considerable political courage. Verrus was wealthy and well-connected, defended by the most powerful advocates of the day. Cicero had to travel to Sicily to gather evidence, interview witnesses, and build his case, all at his own expense and risk. He succeeded brilliantly, but the effort required was extraordinary. Verrus fled into exile before the verdict was rendered, and Cicero became one of the most famous advocates in Rome. The case made his career. But consider how many victims of corrupt officials, lacking Cicero's talents and resources, simply had to accept their losses without hope of redress. The system could produce spectacular justice in the right circumstances, but those circumstances were rare. The question that modern readers inevitably ask is, if there were no police, who maintained order on Roman streets, who prevented crime, who responded when crimes occurred? The answer reveals a patchwork of arrangements that fell far short of modern law enforcement. The closest thing Rome had to a police force was the Vigiles, a corps of freedmen established by the Emperor Augustus in 6 CE. But the Vigiles were primarily firefighters, not police. Their main responsibility was preventing and fighting fires in the densely packed wooden buildings of Rome. Fire was a constant danger in ancient cities, and the Vigiles patrolled the streets at night with water and equipment, ready to respond to outbreaks. The Vigiles did have some law enforcement functions. As night watchmen, they might arrest criminals caught in the act, particularly arsonists and burglars. They could detain suspects until morning, when magistrates would be available to hear cases. But they did not investigate crimes, did not track down suspects, and did not prosecute cases. If you were robbed at night, and the Vigiles happened to catch the thief in the act, you might get help. If not, you were on your own. The Vigiles were organized into 7 cohorts of about 1,000 men each, commanded by the Praefectus Vigilum, an official appointed by the emperor. They were stationed in barracks throughout the city and patrolled their assigned districts. But their primary focus remained firefighting, and their law enforcement activities were incidental to that mission. For more serious disturbances, Rome had the urban cohorts, military units stationed in the city, under the command of the Praefectus Urbi, the prefect of the city. These were soldiers, not police in any modern sense. They could respond to riots, break up major disturbances, and provide armed force when needed. but they were not investigators or crime fighters. They maintained public order through military presence and force, not through detective work or community policing. The Praetorian Guard, the emperor's elite bodyguard, also played a role in maintaining order, but primarily in protecting the emperor and dealing with political threats. The Praetorians were powerful and often politically active. They made and unmade emperors on several occasions, but they were not concerned with ordinary crime. A Roman citizen robbed in the street could not look to the Praetorians for help. What this meant in practice was that Romans were largely responsible for their own security. Wealthy Romans protected themselves with slaves, bodyguards who accompanied them through dangerous streets, doorkeepers who guarded their homes, and household staff who could pursue and apprehend wrongdoers. A rich man travelling through Rome at night might be surrounded by a retinue of slaves carrying torches and clubs, ready to deter or fight off attackers. Poor Romans had no such protection. They walked alone through dark streets without lighting, navigating a city where robbery and assault were constant dangers. The satirist Juvenal, writing in the late 1st and early 2nd century CE, painted a vivid picture of the hazards of Roman streets at night. He describes robbers lurking in shadows, broken pottery and chamber pots thrown from upper windows, and the ever-present risk of violence from those stronger than yourself. You may well be deemed a fool, Juvenal wrote, improvident of sudden accident, if you go out to dinner without having made your will. This was satirical exaggeration, but it captured a genuine reality. Roman streets could be dangerous, and there was no one to call for help. The night watch might be blocks away fighting a fire. The urban cohorts were concerned with major disturbances, not individual crimes. You were largely on your own. The legal right to apprehend criminals yourself, what we might call citizen's arrest, was well established in Roman law. If you caught someone stealing from you or attacking you, you had the right to seize them and hold them for prosecution. You could use reasonable force to detain a wrongdoer. This was not vigilante justice in the sense of taking punishment into your own hands, but it was self-help in the sense of enforcing the law yourself, rather than relying on police. This right could extend to physical force that would alarm modern sensibilities. If you caught a thief in your home at night, you might be legally justified in killing him on the spot. Roman law recognized a right of self-defense against nocturnal intruders that was remarkably broad. The law assumed that a nighttime burglar might be armed and dangerous, and it gave homeowners considerable latitude in responding. But self-help justice had its dangers. If you accused the wrong person, or used excessive force, or failed to bring the accused before a magistrate in a timely manner, you could find yourself facing legal liability. The line between legitimate citizen's arrest and illegal assault was not always clear, and if the person you tried to apprehend was stronger than you, or had friends, your attempt at justice might end badly. For most Romans, the realistic response to minor crimes was probably acceptance. If someone stole your cloak, the time, expense, and danger of tracking down the thief and prosecuting the case likely exceeded the value of the cloak itself. Only when the stakes were high enough, significant property, serious injury, family honour, would most victims invest the considerable resources needed to seek justice through the courts. The role of witnesses was crucial in Roman trials. In a system without police investigation, without forensic evidence in the modern sense, and without professional fact-finding, testimony from witnesses was often the primary or only evidence available. A victim's case might succeed or fail based on whether credible witnesses could be found to support it. Roman law gave considerable weight to the social status of witnesses. The testimony of respected citizens carried more weight than that of the lower classes. The testimony of slaves was only admissible if given under torture. The Romans believed that slaves would not tell the truth unless compelled by pain. This created disturbing scenes in Roman courts, where slaves might be tortured to extract testimony about their master's affairs. The requirement of torture for slave testimony reflected Roman assumptions about status and credibility. Free citizens were presumed to have honour that would compel truthful testimony. Slaves were presumed to lack such honour and required physical compulsion. It also meant that wealthy Romans who used slaves for many activities had to consider that those slaves might later be tortured to reveal what they had witnessed. This created complex considerations about who should be present at sensitive meetings or transactions. The advocates who represented parties in Roman courts, the orators who pleaded cases, and the legal experts who advised on procedure occupied an important social position. Advocacy was theoretically unpaid. Roman tradition held that legal representation was a form of patronage, a service that the powerful owed to their dependents. In practice, successful advocates found ways to receive compensation, often in the form of gifts or political support rather than direct fees. The patron-client relationship was central to how ordinary Romans accessed the legal system. A wealthy patron might maintain dozens or hundreds of clients who owed him deference and political support. In return, the patron provided various forms of assistance, including help with legal matters. If a client was accused of a crime or needed to bring a lawsuit, he might turn to his patron for the resources and expertise needed to navigate the courts. This system meant that legal success often depended on social connections rather than the merits of a case. A client with a powerful patron had access to the best advocates, the most witnesses, and the greatest resources for prosecution or defense. A person without such connections was at a severe disadvantage. Justice was not blind in Rome. It saw social status very clearly. The courts themselves were public spectacles. Trials took place in the forum or other public spaces, with crowds watching the proceedings. Advocates performed for these audiences as much as for the judges, using rhetorical techniques designed to entertain and persuade. Famous trials drew enormous crowds, and the drama of courtroom confrontations was a form of popular entertainment. This public nature of Roman trials served multiple purposes. It provided a form of community oversight, ensuring that proceedings were conducted in view of the public. It allowed ambitious advocates to demonstrate their skills to potential clients and political supporters, and it reinforced social norms by publicly shaming those found guilty of wrongdoing. The punishment of public disgrace was often as significant as any formal penalty. The penalties available under Roman law were severe by modern standards. For serious crimes, the options included death, exile, loss of citizenship, and confiscation of property. For less serious offences, financial penalties predominated. Roman law did not make extensive use of imprisonment as punishment. There were no Roman prisons in the modern sense. Detention was used to hold the accused before trial, but incarceration was not typically the sentence for convicted criminals. Exile was a common penalty for citizens convicted of serious crimes. The condemned person was banished from Rome and often from Italy entirely, forbidden to return on pain of death. This removed the wrongdoer from the community without the state taking on the burden of long-term incarceration. Many exiles lived out their lives in the provinces, permanently separated from their families, properties, and social positions. Death penalties were carried out in various ways depending on the status of the condemned and the nature of the offence. Citizens might be beheaded or given the option of voluntary exile or suicide to avoid execution. Non-citizens and slaves faced harsher methods: crucifixion, being thrown to wild beasts in the arena, or being burned alive. The public nature of many executions served as deterrent spectacle, demonstrating the consequences of violating Roman law. For civil cases, disputes over property, contracts, inheritance, and similar matters, the remedies were primarily financial. If you won a civil case, the defendant would typically be ordered to pay damages. Collecting those damages, however, was again your responsibility. The court would render a judgment, but enforcing it was up to you. If the defendant refused to pay, you might have to seek further legal action, seize property, or find other means of collection. Despite all these apparent weaknesses, no police, no professional prosecutors, justice dependent on private resources and social connections, the Roman system functioned for centuries. How did it work? Several factors help explain its practical operation. First, Roman society was built on interlocking networks of obligation and reputation. A man who cheated his associates, broke his contracts, or committed crimes would damage his social standing in ways that had real consequences. Reputation mattered enormously in a society where business relationships, political alliances, and personal advancement depended on being seen as trustworthy. Social pressure and the fear of disgrace enforced many norms that police might enforce in modern societies. Second, the patron-client system provided informal mechanisms for dispute resolution. Before matters reached the courts, patrons might intervene to settle disputes among their clients, using their authority and influence to impose solutions. Many potential lawsuits were probably resolved through such informal mediation, never reaching the formal legal system at all. Third, the severity of Roman penalties created significant deterrence. The prospect of exile, loss of citizenship, public disgrace, or death made potential criminals think carefully about the risks they faced. And because victims had strong incentives to pursue justice, there was no one else to do it for them. Wrongdoers could not count on crimes going unpursued. Fourth, community enforcement filled some gaps. In close-knit neighbourhoods and communities, residents might take collective action against troublemakers. The threat of mob violence or community ostracism could deter crime in ways that formal institutions could not. This was rough justice, informal and sometimes unjust, but it was a form of enforcement. Finally, for the wealthy and powerful, private security provided protection that police might otherwise offer. A Roman aristocrat surrounded by armed slaves living in a well-guarded house was not as vulnerable to crime as a poor labourer walking home alone. The system's gaps affected different people very differently, depending on their resources. The evolution of professional police forces that we take for granted today was a much later development. The first modern police forces emerged in the early 19th century. London's Metropolitan Police was established in 1829, for example. Before that, most Western societies relied on systems not entirely unlike Rome's. Night watches, constables with limited powers, private security for those who could afford it, and substantial reliance on private prosecution. The Romans might find our modern system puzzling in many ways. The idea that the state would investigate crimes, track down suspects, and prosecute cases on behalf of victims would seem to remove from citizens' responsibilities that Romans considered their own. The Romans valued self-reliance and personal responsibility. They might view our dependence on police as a sign of weakness or civic passivity. On the other hand, the Romans might also recognize the advantages of professional law enforcement. The inconsistency of private prosecution, its dependence on victim resources, and its tendency to favor the wealthy and well-connected were problems the Romans themselves recognized. Some Roman writers complained about the difficulty of obtaining justice and the corruption of the courts. A system that provided more equal access to law enforcement might have appealed to at least some Romans. What Roman private prosecution reveals about Roman society is profound. It shows us a culture that placed enormous emphasis on personal responsibility and self-reliance. Romans were expected to manage their own affairs, protect their own interests, and seek their own justice. The state provided a framework, but individuals were responsible for using it. It also shows us the profound importance of social networks in Roman life. In a world without police or public prosecutors, your connections determined your access to justice. Your patron, your advocates, your witnesses, your resources, all these came from your position in Roman social hierarchies. The legal system reinforced and reflected those hierarchies, providing more effective justice to those with more social capital. And it shows us that societies can function with very different institutional arrangements than we assume are necessary. Rome was not a lawless wasteland, despite lacking police. Romans conducted business, owned property, made contracts, and generally lived orderly lives under a legal system that would seem impossibly weak and inconsistent to modern eyes. They adapted to their system's limitations and found ways to make it work. The legacy of Roman law extends far beyond the specific procedures of Roman courts. Roman legal concepts, contract, property, evidence, procedure, the idea of law itself as a system of rules and principles, shaped the development of Western law for 2 millennia. Medieval and modern legal systems built on Roman foundations, often consulting the great compilations of Roman law, like the Digest of Justinian, for guidance and precedent. But the specific mechanism of private prosecution did not survive in most later systems. The inefficiencies and inequities of relying entirely on victims to pursue justice became increasingly apparent as societies grew more complex. The development of professional police forces and public prosecution reflected a recognition that effective law enforcement required more than private initiative and social networks. Today, we take professional law enforcement so much for granted that imagining its absence requires real effort. When we call the police after a crime, we expect officers to respond, investigate, and take action. We expect prosecutors to bring charges and pursue cases through the courts. We expect the state to enforce the law, not just provide courts where private citizens might seek justice if they have the resources and determination. But the Roman experience reminds us that this is not the only way to organize a society. For centuries, millions of people lived under a system where justice depended on private prosecution, where victims bore the burden of law enforcement, and where social connections determined access to legal remedies. That system had serious flaws, but it also functioned well enough to sustain one of history's most successful civilizations. The dark streets of ancient Rome, where citizens walked in fear of robbery and assault with no police to call, represent a world profoundly different from our own. Yet the Roman Forum, where advocates argued cases and magistrates administered a sophisticated legal system, represents a world that contributed enormously to our own legal traditions. Both realities coexisted in the Roman experience. When we walk past a police station or see a patrol car on the street, we are benefiting from institutional developments that would have seemed remarkable to the Romans. The idea that the state would maintain armed forces specifically to investigate crimes, apprehend suspects, and protect public safety, all at public expense, represents a significant investment of collective resources and a particular vision of the state's responsibilities. The Romans made different choices. They invested in courts, laws, and legal procedures, while leaving enforcement largely to private initiative. Their system produced remarkable legal sophistication, alongside profound inequality in access to justice. It worked for centuries before giving way to different arrangements in the medieval and modern worlds. Understanding how the Romans approached justice without police helps us appreciate both the universality of human concerns about crime and safety, and the remarkable diversity of institutional responses to those concerns. Every society must somehow maintain order, resolve disputes, and address wrongdoing. The Romans found their own way, one that shaped legal history while differing fundamentally from what we consider normal today. So the next time you see a police officer, consider what the Romans would have thought, and what life was like when justice meant tracking down criminals yourself, dragging them to court yourself, and prosecuting your case before judges and juries, with no help from the state. It was a different world, but it was the world that built the foundations of Western law and taught us that legal systems can take many forms. The victim walking home through Roman streets, wondering whether to pursue justice or accept his losses, faced choices we can barely imagine. But he was part of a civilization that still shapes how we think about law, justice, and the responsibilities of citizenship.